Is it ever appropriate for an attorney at trial to make an objection while sitting down? You want to know the answer? Come join me on this quick walk because I share with you the answer to that question. Hi everybody, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is no, it is not appropriate. In court, anytime we need to let the judge know that there's a problem, either a problem with the evidence, or a problem with a question that's being asked, or a problem, some issue that's going on in court that I need the judge to take notice of and to act on it. Anytime that happens, I need to do that in a way that alerts the judge immediately. And what's the proper way to do that? I have to stand up, jump up out of my seat, and yell out, "Objection, Judge!" And now I have to tell the judge concisely exactly what my objection is. "Objection, Judge, that's irrelevant," meaning that the question that's being asked of this particular witness is not related to the issues in this case. And then the judge will have to decide immediately whether or not what I have just argued is correct. And if he agrees with me, he's going to say objection sustained, which means that the question cannot be asked and the witness is not to answer that question. On the other hand, if the judge disagrees with me, he's going to say objection overruled, which means, no, I'm disregarding your objection, your concern, counselor. Go ahead and answer the question, Mr. Witness. There are many times where an attorney during the course of trial is too lazy, actually too lazy, to get up out of his seat and yell out objection. So what happens then? Some judges are sticklers for this, and I see this over and over again when I walk into courtrooms to see what's going on during a trial. And sometimes, during the middle of a trial, an attorney will have a problem with something that's going on, and instead of jumping up out of his seat, he will sit at his table, at counsel table, and mumble, really mumble. He's like, "Objection, Judge," expecting the judge, number one, to hear him, and expecting the judge to give him an answer. Sometimes the judge is so busy or so engrossed in doing paperwork, he doesn't even hear it. And now the jury doesn't even see it or hear it. Why? Because the attorney is sitting at his table. He thinks he hears something that's improper. He simply mumbles, "Objection." And what happens then is that he's anticipating, the attorney who just made this objection, is anticipating that the court stenographer, the court reporter, will simply record that objection down in the record, and now they'll just keep moving on. The problem is, the judge has to make a ruling anytime an attorney makes an objection. It's called preserving the record. So an attorney thinks that something's being done improperly. He has an obligation to jump up out of his seat and yell out, "Objection, Judge! That's irrelevant. Objection, that's hearsay," or whatever the objection is. And now the judge will immediately make a ruling on it. Or he'll take oral argument and listen to the legal arguments to make a decision. But to go ahead and make an objection while sitting down is actually disrespectful. And many judges at the very beginning of the trial, before the jury is allowed to come into the courtroom, the judge will sometimes instruct the attorneys that, listen, if you have an objection, you better do it standing up, because I will not tolerate objections that are sitting down. It's disrespectful. And you'll find that the best trial attorneys in New York always stand up to make an objection. When making an objection, you want to be able to stand up, alert the court, alert the jury, alert everybody in the courtroom that there's a problem. And now you want everything to stop, and you want the judge to immediately act on that objection. So why do I share this quick information with you? I share it with you just to give you a sense of what really happens in these medical malpractice cases in New York. You know, I recognize you're likely watching this video because you see the beautiful scenery. No, that's not why. I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York, and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need answers, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.